Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the topic exhumation, Exhumation, or disinterment, Disinterment, disownment. Legal provision is section 176 of the CRPC. Of course, here the Supreme Court yesterday, that is on 12/9/2022, two judges bench, Justice Suryakant and J.B. Pardiwala, while discussing the case of Mohammed Lateef Magrey, maybe from Pakistan, Mohammed Lateef Magrey versus the Union Territory of Jammu and Kashmir in Civil Appeal number 6544/2022, held that actually it suggested an appropriate law on the topic of exhumation. And in this connection, Supreme Court clearly stated the human rights. Once buried, when a dead body is once buried, please remember, should not be disturbed as per the religious rites. This is the baseline. But sometimes we have to get it interned, we have to get it disinterred, we have to get it exhumed. Then this topic will come. So I told you section 176 and other things, we will come to the topic later because it is investigative part. But here, better to know the details of the case first. Alright. The appellant, that is Mohammed Lateef Magrey, is the father of the deceased Mohammed Amir Magrey, who was killed in Jammu&Kashmir, hyderpora encounter, which occurred between the police and militants in Jammu and Kashmir. This is the problem. So this Amir Magrey, who is the son of our appellant Mohammed Lateef Magrey, is reportedly a supporter or the so-called militant in Jammu and Kashmir. Right? So during the encounter, some police people die, and sometimes these extremists also, the militants, they die. These people died. At the outset, they were not be identified. That's the main problem. Nobody came to claim the dead body. Out of these four people, four militants were killed. Out of them, two claimed the dead bodies and they were taken away. Since nobody has come forward, then they were given a decent burial by the local officers. Now his father, that is Magrey, Mohammed Lateef Magrey, having come to know that his son has been encountered, he approached the local court, ultimately court of Jammu and Kashmir, to see that the body is exhumed to conduct the religious prayers. And Jammu and Kashmir High Court permitted the appellant and 10 of his family members to perform the so-called Fatiha Katwani, Fatiha Kahani, I don't know, that is religious prayers, let us understand, while declining to exhume the body. Only thing is, you can go and conduct the prayers at the place where the body was buried, but it will not be exhumed. This is the order given by the High Court. So aggrieved by the order, he approached now the Honorable Supreme Court of India. You know, the encounter took place on 15/11/2021. Out of 4 militants who were shot dead, 2 were identified, bodies were handed over in crime number 193/2021 under section 307, 120B and 27 of the Arms Act and Unlawful Activities Prevention Act. All sections. 307 is, attempt to murder, 120B is criminal conspiracy. Right? The IO has identified 2 dead bodies. Ultimately, these 2 were also identified, but nobody claimed. Therefore, they were buried in Hardwara, Jachalda for burial. Okay, whatever it is, following the religious premises they were. Now, the point is whether they can be exhumed or not. In this connection, a famous quotation was given by the Honorable Supreme Court of India. Justice Cardozo, in the case of Yomi versus Gorman, 1926, in USA. He said, "The dead are to rest where they have been lain. So where they are buried, where they are laid, they have to take rest unless reasons of substance is brought forward for disturbing their repose. So if there are reasonable grounds, yes, they can be reposed or they can be exhumed. So normally they have to be laid in rest. So the dead body of the son of our plant has been buried. So then he approached various authorities to hand over the body, but to no use. Ultimately, he filed petition before this honorable court. So now the Supreme Court said the exhumation involves opening of the grave. Is it not? Definitely exhumation. I will tell the provisions under 176. And definitely removing the human remains. It is controversial. Some people like it, some people don't like it. Most societies, they are reluctant for shifting of the dead body once buried. So, a right to die, Article 21 says, a right to life, at the same time, a right to die with human dignity. So, ultimately, cannot be disinterred, cannot be exhumed. In this connection, Supreme Court asked the lawmakers, that is the states of Jammu&Kashmir or the Union of India, to make an appropriate law in this connection. That means when the bodies can be disinterred. Now coming to the investigation part, section 176 clause 3 crpc. You all know 174 deals with the inquiry regarding the suspicious deaths or police to require inquiry into suicide or deaths other than under natural circumstances. 176 inquiry by magistrate into cause of death by magistrate. So normally when a woman within 21 years, if she dies, within 7 years of marriage, if she dies, or when a person dies in police custody, when there is suspicion regarding the death of a person, all these things will come under 176. Now, if the body is buried according to 176 clause 3 crpc, whenever such a magistrate considers it expedient to make an examination of the dead body of anybody who has been already interred, already buried, then in order to discover the cause of death, yes, the magistrate may cause the body to be disinterred and examined. Yes, if the magistrate is satisfied, yes, he can do it. So normally there are occasions where a person dies, the report is that he died a natural death, and the body is buried. Ultimately, his relatives come forward and say that no, there is some suspicion. Other people might have done to death and buried the dead body. If you take out the dead body, if you conduct the PM examination, the real facts will come out to light. Yes, in such a case, the magistrate can examine the witnesses, he should be satisfied, then only he has to give order for the so-called exhumation or disinterment. He has to be satisfied. Magistrate means, please remember, executive magistrate. Number one. Second, a person dies, postmortem is conducted, and ultimately it is buried. But some other people, they get a doubt and they get reasonable doubt. In such cases, second postmortem will be necessary. In the case of militants, this case, just like this Mohammed Lateef Magrey. So the courts will order for second post-mortem examination. Yes, such times also disinterment is necessary. Otherwise, normally people feel bad. We have faced so many situations where the people are not willing to cooperate with us, and the magistrate has to be satisfied. He has to record the statements. Unless he is satisfied, he will not give orders. The other side, there is a heavy pressure. We have to convince those people. There are occasions where we had to convince those people. Anyway, so now Supreme Court not allowed, please remember, not allowed to disown the body. In this connection, they have discussed a law of Ireland. Few countries like Ireland, they have legislation for exhumation. It's according to section 46 of the local government, within bracket Sanitary Services Act 1945. Yes, it allows the shifting of the bodies in case of necessity. So therefore, the Honorable Supreme Court of India opined that it would be appropriate for the government to make a law on the exhumation. This is the suggestion given by the Honorable Supreme Court of India. Let us see what will happen. Okay, thank you.